This is Brother Medina for the Tusian Institute of Religious Liberty, and we want to talk about the United States Supreme Court ruling on same-sex marriages. We are told that states are required to grant a marriage license to same-sex couples and recognize valid same-sex marriages from other states. This is what we are told, among others, from the Supreme Court justices. However, there are troubling things about this ruling, and we want to do a little presentation on this ruling to show what is wrong with it. The US Constitution says nothing about genders, nor the new definitions of genders that are currently in American thought. The US Constitution says nothing about this. The rights and freedoms outlined in the Constitution are assumed to be for all, and hence it covers both genders, male and female, that all the human race fall into. So when the US Constitution has rights and freedoms, those rights and freedoms are assumed to be for all in the Constitution. And by all, both genders are being referred to, both male and female genders. Furthermore, marriage is not even defined in the US Constitution and is not held as an issue in that document, but is assumed to be between one man and one woman, as was traditionally believed by the founders of the United States. Yes, my dear people. The Supreme Court is not the legislative. It is not the legislature. Hence, it has no authority to create and write laws for the Union. This belongs to Congress and Congress only. So that the Supreme Court is not the legislature. They are not supposed to legislate laws. All the Supreme Court can do is to make pronouncements or to make rulings based upon laws that already exist in the Constitution. The facts are, the Supreme Court is an institution that belongs to the judiciary, hence it's supposed to give rulings based upon the laws of the Constitution of the Union, all 50 states. Or it can rule certain laws to be unconstitutional that goes against the written Constitution, but it has no authority to write laws from the bench. So that the Supreme Court is not supposed to write laws from the bench for anyone. This is a fact, and this should be known by all. This shows that the Supreme Court has no legal authority, and mark these words carefully. The Supreme Court has no legal authority to give rulings that are linked to new definitions of gender or marriage for all 50 states of the Union. And these are not subjects existing in the US Constitution, and they are given no definitions in that document. Hence, the Supreme Court have no authority, no legal authority to give rulings that are linked to gender or marriage. Hence, any ruling made by the Supreme Court with regards to gender or marriage just cannot be right. Yes, my dear people. Equal opportunity for all genders, male and female, already exists in the Constitution. So if you check the US Constitution, equal opportunity for all genders, both male and female, already exists in the Constitution, but not the subject of same-sex marriage. This doesn't exist in the Constitution of the Union. Since the Constitution says nothing about marriage, any ruling from the Supreme Court that touches all the states of the Union must be neutral on the issue of same-sex marriage. Yes, my dear people. Since the facts are that the Constitution of the United States does not give a definition of marriage, and it says nothing about marriage. The facts are, and it says nothing about marriage, the facts are that any ruling the Supreme Court makes on marriage must be neutral. A ruling on same-sex marriage was decreed by the Supreme Court recently, and it also calls for all states to issue marriage license that all must recognize as valid. Even though the Supreme Court made that ruling, it does not justify it as constitutional. So that ruling is not justified as constitutional, for there is no constitutional law for the 5 judges that made that ruling to base their ruling on. So if the 5 judges of the Supreme Court, there were 9 and 5 made that ruling in favor of same-sex marriages, since those 5 made that ruling, there were no constitutional laws that exist upon which they can make their ruling. So this would mean that the ruling was wrong, it was illegal, it was unconstitutional. This ruling has illegally written a new definition of what constitutes marriage, since it is about same-sex marriage, and the judges of the Supreme Court had no legal constitutional authority to do so. So here, if they agree to same-sex marriage license being granted by all states to all people, it would mean that the Supreme Court has already subtly given an impression that marriage can be between a male and a female and a female. But this ruling was illegal. On what basis did the Supreme Court make that judgment that gave a new definition of marriage? This means the whole thing was illegal. The whole ruling was illegal and should be withdrawn. Their ruling that was illegal should be reversed after consultation among all the 9 judges. Yes, my dear people, this is what must be done. Since there are no constitutional definitions of gender or marriage, but only sensible assumptions exist about them, the best act the Supreme Court can do is to keep out of such issues and to let the states decide for themselves, since this is a constitutional power the states of the Union already have. The better thing for them is to keep out of issues like this. If the judges revoke their decision, this shall help in curbing the already piling up of discrimination against Christians and conscientious objectors who, for moral and religious reasons, refuse to cooperate with same-sex marriages. So Christians and people who have conscientious objections refuse to cooperate with same-sex marriages, and they are identified as discriminating against gay couples. But it so happens that this piling up of discrimination against Christians, who also are facing discrimination by gay couples, this ruling, if the United States Supreme Court withdraw that ruling, this ruling will help stop the abuses against Christians and conscientious objectors. If the cry of discrimination trounces liberty of conscience for some, then discrimination still exists against conscientious objectors. This is also the absence of equal opportunity for all. Yes, my dear people. So we call upon the judges of the Supreme Court to think again and to withdraw their ruling, to change their ruling, and to make their ruling different than it was before, because they have no authority to rule on marriage. It is not to say that Congress had written a law on same-sex marriages and had imposed it upon all the states, and then somebody brought it to the Supreme Court for judgment? No, no such law exists. Yet the Supreme Court makes a ruling that redefines marriage and that tells people same-sex marriage must be followed. This is the Supreme Court writing laws from the bench, decreeing laws where laws do not exist. The best thing for the Supreme Court to do is to follow what the 4 dissenting judges said. Leave it up to the states to decide. Now, there are a number of things that exist today among this argument about same-sex marriages that needs to be understood. And what we have done, we have given certain terms to explain what is being done. One of the terms is called more equal legislation. More equal legislation. Now, legislations that justify same-sex marriages and that call upon Christians to cooperate with it, such legislation we call more equal legislation. Now, here is why. Since all men were given the same rights and freedom by God, and this is what the US Constitution contextually recognizes by inalienable rights, since all men were given the same rights and freedoms by God, and therefore naturally possess them, all men are equal under law and under the US Constitution already. Legislation that grants provided opportunities to special interest groups and calls it rights and freedoms make those special interest groups possess more rights and freedoms than the average people already have under law. And this breaks the principle of equal under law that people already have from the Constitution. Such legislation we call more equal legislation. And more equal legislation are wrong. Yes, my dear people. There is also something we call meta-gender legislation. Meta-gender legislation. Meta meaning beyond. So it is really beyond gender legislation. Now, such legislations also exist in some states of the Union. Any legislation that goes beyond the 2 common genders that all people already fit into, listen to this carefully, any legislation that goes beyond the 2 genders that all peoples already fit into, and that is for the sake of including some people's choice and habits of sexual preference or orientation, such legislation is called meta-gender legislation. That is wrong. Because what you are taking some people's sexual preferences, which is their choice, and sexual orientation, which is their habits, and you are legislating these, giving to them what you would call more rights and more freedoms than they already have in the Constitution and than normal people already have in the Constitution. That is wrong. And that is what you identify as beyond gender legislation. Any legislation beyond gender is obviously wrong. You cannot write laws for genders that doesn't exist. You cannot write laws going beyond gender for genders that already does not exist. Yes, my dear people. Furthermore, we have 2 types of discrimination. We have what we call judgmental positional discrimination. Judgmental positional discrimination. And this everybody must have. Everybody must have judgmental positional discrimination. This is the individual exercising of values, discretion, and adoption of a lone position among many to resonate with your conscience. So here you have many different views going around. And you exercise your individual values, discretion, and you adopt a lone position among the many positions, and this position you adopt resonates with your conscience. It's according to your conscience. You call that judgmental positional discrimination. That is freedom from God. That is freedom of thought. That is freedom of conscience. That is freedom of belief. That is freedom of opinion. That is those freedoms. And those freedoms there, we need to understand, are right and true and are freedoms that exist under our Constitution. So when a person exercises judgmental, positional discrimination, he is actually exercising his freedoms. There's nothing wrong with that discrimination. And if you use that to decide that you're not going to follow or cooperate with same-sex marriages, it's your freedom. And it is your right. And it is not wrong. No court should demand that you bake a cake for someone when you disagree that it is, when you think it is wrong. No court should tell you to pay them because you disagreed with what they are doing and you refuse to cooperate with what they are doing. This is just exercising judgmental positional discrimination. And then there is something called reverse discrimination. Reverse discrimination. Reverse discrimination is wrong. This is described as this. It is the act or policy by the use of law of preventing discrimination against a person, persons, or groups which act on policy at the same time, and it discriminates against the accused. In other words, whenever you are seeking to prevent discrimination against a person, persons, or groups, and you have an act or a policy that at the same time discriminate against the accused, that is called reverse discrimination. And if discrimination is wrong for that group, then reverse discrimination is also wrong for the accused. And this is what gender-based laws or laws that go beyond gender and same-sex marriages are doing today. They are creating reverse discrimination against Christians. And then there is something called anti-rights and freedom discrimination. Under that you have reverse discrimination. Now, anti-rights and freedom discrimination is any form or behavior or laws that goes against the legitimate rights and freedoms of man. Notice, the legitimate rights and freedoms, not trumped up rights and freedoms, not added rights and freedoms, which are no rights and freedoms. Sexual behavior can never be a right. Sexual practices or habits can never be a right. And marrying to gratify those habits is not a right also. They are merely provided opportunities, and it is based upon people's choices. But Christians also have their choices too. And this is what we call moral preference. Moral preference. By the use of freedom of thought, freedom of opinion, freedom of choice, and by the use of discretion, and the forming of and adopting a moral view and position that is in accordance with freedom of conscience, you call that moral preference. So if you form a view that is based upon your thought, your opinion, your choice, and using discretion, and that view is based upon your freedom of conscience, it is tied into your freedom of conscience, that's your moral preference. So your moral preference is right. But why are we saying that there is sexual preference and a person's sexual preference must trump your moral preference? He can have his sexual preference, but you can have your moral preference. Your moral preference is protected as a right and as a freedom. It is the right of religious liberty, and it is the freedom of thought, freedom of belief, freedom of opinion, freedom of conscience. All these fall under our moral preference. And one last thing we would like to talk about. We would like to talk about discriminatory equal opportunity legislation. Discriminatory equal opportunity legislation. This term identifies a type of legislation that exists. It is discriminatory and it is equal opportunity legislation. Let's look at the definition here. Equal opportunity is equal provided opportunities, or what we call provenities. But to attach these provenities, especially marriage, to equal opportunity, it is to still deny some equalness of marriage to others. In other words, if a male and a male and a female can marry, which we call same-sex marriages, and that is equal opportunity to them, then there must be equal opportunity for polygamy. One man should be able to marry 8 wives. One woman should be able to marry 8 husbands. That's equal opportunity attached to marriage also. Also, a man can marry a little child, or 2 children wanted to marry can marry of opposite sexes or of the same sex, because all of that fall under equal opportunity with regards to marriage. Why just same-sex marriages? If equal opportunity is the heading for same-sex marriages, but you deny it to the pedophile, but you deny it to the polygamist, but you deny it to the woman who wants 5 husbands, then there is no equal opportunity there. So that is what you call discriminatory equal opportunity legislation. All equal opportunity legislation that relates to what we call same-sex marriages are discriminatory equal opportunity legislation, because it doesn't go far enough for anybody who wants to marry whatever they want to marry. So this shows us that sexual preferences or orientation, which are choices and habits, and they are in a limited sense, while there are many other choices that exist, must not be the subject of equal opportunity. For if it is, we call that discriminatory equal opportunity legislation. So, what do we say here? These terms were used to show the kind of destruction that have been going on the American legal scene, the type of destruction that have been going on in society at large by proponents of gay marriage. By the Supreme Court therefore joining on the wrong side, the Supreme Court has encouraged all these abuses in law, all these wrong types of legislation. Therefore, the best thing for the Supreme Court to do is to reverse their judgment and leave it to the states to decide. There is no legal basis for the Supreme Court to judge on same-sex marriages. There are no laws defining same-sex marriages. There are no laws defining marriages. There are no laws defining gender. It would be better for the Supreme Court to leave it to the states, but make it become plain that the US Constitution cannot be used as the document, as the grounds for justifying same-sex marriages. And any state that recognizes what these Supreme Court justices have done must call upon them to withdraw their decision. Because to impose it upon states that say no same-sex marriages is to give the impression there is something constitutional there that those states were not following. But there is nothing constitutional there on that. Therefore, that is not a law that was ruled upon by the Supreme Court. But the Supreme Court made a decree which was like a law for all the states to follow. And that was completely illegal. It was completely wrong. It should never have been done. So again, we call upon the Supreme Court justices to remove this clearly before more destruction takes place upon the land. The evils that attend same-sex marriages and the bad legislation that attend it in different states have now been strengthened by the Supreme Court's ruling. They need to withdraw that ruling so that those evil types of legislations, those destructive anti-rights and anti-freedom types of legislation can be removed also. May God bless you judges, all of you all, as you make the right decision, as you make the right position before it is too late. May God help all of us before the world sinks into a morass of sexual corruption parading under the guise of freedom, equal opportunity, and rights. Amen.